Welcome, everyone. Evening.
If we can get it done in 2 minutes. That'd be great.
Is it? Yeah. I had to move it down because it was banging on my thing here. Well, welcome, everybody. Thanks for coming out to learn about governance and decision-making and how things sort of work together for the Board of Adjustment and the Planning Commission. The overarching goal here is to sort of give you a big picture of how everything interacts together and what kinds of things go into the decisions that you make, how all these different parts could work together constructively with staff and county attorney's office and the board and all the stakeholders involved in these processes. My name is Steve Kranz. I'm an assistant county attorney, and I handle the land use issues for the county. Basically, I handle all the non-criminal issues for the county. So first off, I just want to thank everybody for volunteering for public service, which is usually a lot harder and less exciting, but more important than people think it is. The nice things about both the Board of Adjustment and the Planning Commission is that these are bodies that represent the public voice before the board makes decisions or in variance or land use decisions. And that's a really important part of land planning and land use issues, is that the decisions that are made are guided by what the community needs. And you all have a very big role in doing that. So I'm going to start just by discussing a little bit of what planning is, and really want to emphasize that it's a community process. It's not all people sitting in locked conference rooms in the administration. But basically, the managing development county land and safeguarding public resources. The state gives the counties the authority to regulate. The county needs to follow any statutes or regulations, but then can create ordinances that govern how we use our property in the community. And then planning and environmental services staff, they're interface directly with the public and with you guys and with the board. And I think I'd like, so some of them are here, so I think it'd be nice if they introduced themselves, and then maybe we could go around and just everybody introduce themselves. Might be a nice way to go here.
Well, I'm Doug Cieslak. I'm the Director of Planning and Environmental Services.
Eric Johnson, who was zoning administrator.
Ann Schwartle, I'm the Administrative Specialist for Planning. Olivia was from a planner.
Lou Overhout, I'm planning with the department as well.
Marcia Ward, when I'm planning. And Randy, Mark Justice.
John Nicholson, planning commission.
Eugene Anson, Planning Commission.
Jordan Potter, I'm the liaison to the planning commission from the Board of Adjustment.
Amy Cordry, Board of Adjustment.
Steve Holm, Planning Commission.
And I'm Chef Osted, Planning Commission.
Okay, thank you. Well, all these people are smarter than me about planning issues, so I've told them to interrupt me if I say anything incorrectly, or if they have information they'd like to add, and I'm hoping they may come up and share some things as well as we go along. So there's basically a flow of decisions that lead to the decisions you make. The starting point of everything just about is the comprehensive plan. And that's by statute. We have to have a comprehensive plan and update it every 10 years. And it's basically meant to be a comprehensive community input process where the goals and vision for the community 10 years from now are agreed upon and written up. And then the ordinances are designed to lead to that outcome. So decide, where certain types of land uses could be or not be, or how natural resources are going to be protected. All that starts with a comprehensive plan. I sort of think of it as like the Constitution. So like we have ordinances, which are like our laws in the county, and then the overarching guiding principles come from the comprehensive plan. In the same way, our laws ultimately end up being representative of the values of the Constitution, hopefully. And we're actually just starting the process of the update to the comprehensive plan. We were supposed to have it done in 2024 according to the statute, but no one's come for us yet from the state. But that process is just getting underway, and will be over the next several months, and will end up in a comprehensive plan update, like the last one you see there.
That's okay, Steve. The state couldn't get marijuana rules done by their deadline, so
Yeah.
they don't have a leg to stand on.
Oh, yeah.
Yeah.
That's for sure. Yeah, we've been working on those cannabis ordinances, and it is very difficult when the state hasn't released their guidance or administrative rules. So yeah. So I think, generally I think people know this from social studies class. We have different sources of law: the Constitution of the United States, the Minnesota Constitution, state statutes, administrative rules, which are regulations that agencies are authorized by the legislature to adopt that basically have the force of law, ordinances that the county does, case law, which is one thing about any statute, constitution, or ordinance. There's often a little bit of ambiguity in it because you can't account for every situation that happens in the real world. And so often, if there's a disagreement about what a law means or a word means in a law, someone will file a lawsuit and the court will rule on what that is. The district court rulings have no precedential value, but if it goes up to the appeals court and the appeal court makes a ruling on it, then that has precedential value. And that's if we had a statute and that had a word and they said it should be interpreted this way, that's what we would do. And then county authority to enact zoning regulations does come from the legislature. Constitution allows for the creation of local government units, and the county's authority to enact and enforce zoning regulations is granted through statute by the legislature. And one thing to notice here, or to point out here, is that there's some fluidity. Things change, and there's unexpected things like Minnesota's constitution has certain protections that are stronger than the federal government's in terms of exercise of religious freedom or speech. And state statutes change from year to year. And case law changes as well. And the case law is a little tricky because you don't normally, it's not very public when a case is decided that changes the way you have to do what you do. So that's what we try to keep up with at the county attorney's office.
Steve,
Yes.
okay, you got that circle thing, it's state power, county zoning, and township zoning.
Mhm.
Where does we put in Winona County, city of Winona, and the other cities in Winona County?
Yeah, so the cities would go in basically the same ring that the county is in. So they have their own ordinances, and the statutes also give the cities the same kinds of rights that the county have to adopt ordinances and laws. So, and the one that's missing there is federal, of course, it would be around the whole thing. So the cities function very similar to counties in that way.
They don't have to follow any of our laws.
Right, right. They, right. Yeah. Yeah, that's what I meant. It would be within the state power circle, but not within the county circle. And then, and things get decided. So like, you could pass an ordinance, or we could pass an ordinance, and somebody could decide that's not constitutional. And if they file a case, that will go from the district court to the Court of Appeals, the Minnesota Court of Appeals, to the Minnesota Supreme Court, and then it could go to the federal Supreme Court from there. And so in that way, you sort of get the federal constitution really sort of overriding everything, because everything has to be constitutional under the federal constitution. But the Supreme Court hears very, very few cases each year compared to the thousands of submissions they get. And then within Minnesota, the state stuff that doesn't impact the federal constitution would stop at the state Supreme Court. And at each level, the next level up supersedes the level below. So if the appellate court overturns a district court decision, it's the appellate court's decision that has legal precedential value. If the Supreme Court overturns the Court of Appeals, the Supreme Court's decision has the presidential values. So in looking at laws, you have to sort of consider or cases, you have to consider the source and the court and what jurisdiction they had in order to determine how it impacts what you're doing. Oh, look, there we go, federal power. Federal power came in late, I don't know what it was doing. Okay, so this part of the Constitution relates directly to what you do. So there's two constitutional protections that apply really closely to your work on your committees and boards. The 14th Amendment is equal protection and basically says that one group can't be unduly favored over another group. So if you have two similarly situated groups of people, you can't treat one person one way and the other person the other way. In a land use decision, it might be, well, we're going to let this person do it, or we're not going to let this person do it, and you don't have a reason for a legal basis to do that that isn't discriminatory. And then the 5th and the 14th Amendment is due process. And again, these are two things that apply directly to what you're doing: procedural due process and substantive due process. So the Constitution requires that the process be fair and the procedure be fair, and that people have notice of what's going to happen, and that they have an opportunity to be heard, and that there's a record that supports the decision. So what this is basically, bureaucracy exists because of this rule. Bureaucracy that, I mean, it goes amok, but the original intention is to make sure everyone's treated the same. Everyone goes through the same steps to reach a certain outcome. And so the procedures that we use on the committee are important. Our public hearings have to be conducted according to our ordinances and statutes, how they need to. If we're going to let, say, one person speak, we probably have to let another person speak if they both have different sides of an issue. And we have to design our process so that it is fair and is impartial. And then substantive due process basically means there has to be a rational basis for the decision. So this is where those of you serving on the boards already are familiar with the findings of fact. So the findings and facts that describe why the decision is being made is to satisfy substantive due process. So basically, when you're deciding on a variance or a conditional use permit, there are factors that are both statutory and in our ordinances that say these are the things you need to think about. And there's, I don't know, 8 or 10 of them or something. And so those findings of facts, the planners will review the petition or application, and they'll recommend what they think meets or doesn't meet those findings of facts, and then I'll review it and try to draft findings of facts that would pass muster under the substantive due process standard. And one thing I want to emphasize about that is that just because we draft findings of facts, you do not have to adopt those. You're the decision makers. We're there for, to counsel you and help you with legal aspects of things. A lot of that work is done ahead of time, though, because it does take a long time to do it correctly. So if you try to do it while you're sitting at a meeting, you may end up being there a long time and ending up with something that is not maybe as justifiable as it would if you could research the issues when you draft it. Yes.
Done this longer than, like Eric's the only one that probably exceeds my experience with this. We have had planning directors in the past, when a conditional use permit came up, there was findings of fact provided us to approve, and there were findings of fact to disapprove. And now I've seen the tendency over the last several planning directors is that it always seems, again, they tend to approve. The facts tend to lead towards an approval. So is there any reason that we can't request? And again, when you write out findings of fact to approve, and as you just said, you're sitting in a meeting and you figure that maybe that's not really what you want, but it's difficult to change because you've already been presented that information ahead of time. So is there anything precluding us from asking for pros, in my opinion, pros and cons?
There's nothing precluding that. You could ask that from us. The one thing I would say, we have limited resources, and that's a double of the workload for each meeting. The one thing that can happen, though, that would not be as difficult on resources, would be if there's things that the commission or the board wants differently than what's in the findings of fact. You can describe what those things are and direct the staff to draft those. And so that would then allow you to change things without having to, stay at the meeting all night while we draft legal verbiage.
Steve, if I could add to that, I think one of the things, Marcia, that may have led to that change is there was a change in the ordinance and where there was an amendment. And in that amendment, it has that the director is going to make a recommendation.
Which ordinance is, I don't know. Okay, tell me which one that is.
I have the,
Is it one investment one? And
yeah, I don't have the specific
okay,
citing right now.
you can provide that to me.
Yep.
So,
And it just says that
but there again, the planning, no
director,
offense, planning director is one person's opinion.
that's right. And I'm only adhering to what the ordinance
Yeah, okay,
says. So,
yeah. Reference that to me.
and I think that's might be, then it's artifacted in, the findings of facts that shows, those points the director is.
Sure.
And just so you know, I don't just stand up on high and decide. It's
Well, like I
a
said,
group decision.
I've experienced different processes.
Yeah.
So I bring that up.
Yeah,
Yeah, in fact, what Marcia was asking about was those pros and cons, and that was done with just variances. Everything's before we had findings of fact, accompanied document. So basically what they were choosing from was the record. And when they adopted, either they had a choice if they saw through that request, whether it be board or there was reasons why they should consider it or could ultimately deny it. And that became the findings of fact. It was a tool before we got to the point of having a much more thought out, developed findings of fact with the assistant county attorney's office. So they've been
It's
much more
also,
involved with us.
it's also, if you go to those MCIT trainings, where the attorneys are essentially giving this type of a presentation to people across the state, usually it's welcome staff, so
Sign in.
they go to, and they recommend it to be done kind of the way that we're doing it. They provide some tools and guidance as to, you know, how you go about making findings, you know, if the board finds that they want to go a different direction and they disagree with one or two of those findings, you know, how you get to those decisions, but they really recommend the kids, everybody's saying the kind of the A and the B or the pro and con. I think for legal reasons, you know, if you were to be challenged, you know, they're essentially saying, well, you know, you provided the rationale for him, you know, in your staff report.
Right.
So
Well, you should never have one lawyer, in my opinion, either. You should have a subject. It's a matter of interpretation and opinion.
And you're the mayor tiebreaker, right?
Yeah, I'd love to have another lawyer here. That'd be great. Maybe you could bring that to the board. And we'll talk about that more further as we get into more talk, the specifics of what the planning department does. But I don't want to say that all that stuff can't be done. It can be done. We can sit at meetings and draft it out if that's what the board wants to do or the commission wants to do.
One more thing that's
Sure.
piggyback on that comes to mind is that when you are doing that, really what we're looking for is why? Why is that change being made? So whenever we're looking at the criteria, it's like yes or no, it meets the criteria, or it doesn't, and why?
Why
So
are
when you're looking through it, that's kind of the thought process, and you want to state, and that's what the discussion is for when you're going through it, is to get at that why. And if you can provide some rationale as to why you're coming to that conclusion, then we can help draft that finding to help the board, you know,
Yeah.
make the decision.
And I would recommend that if and when that type of thing happens at a meeting, you really need to slow it down and make sure that there's a really coherent discussion about it and that we have time to put the right words together. I had in private practice before I worked here, I had a land use case for a client that had been denied a conditional use permit. And basically all I did was transcribe the board meeting and put it into a complaint, and their statewide attorney turned around and told them, you need to change your vote. Because they did none of that. It was all just sort of off the top of their head, what they thought about it, how they felt about it, not looking at their comprehensive plan, not considering a specific set of findings. The language is really important, and the discussion and dialogue is really important, because all that is the record that, you know, if it's litigated, that's what will determine the outcome. In that particular case, that case that I worked on, in that case, I think it was the city council, but they just did not pay any attention at all to their comprehensive plan or any specific factors as to why they thought that conditional use permit shouldn't be allowed. And it's a violation of procedural due process and substantive due process. So, okay, so one day I'm going to turn these the right direction. Okay, so I talked a little bit about how things flow. So starting with the comprehensive plan, you get the public participation and value statements. There'd be data gathering and analysis and different maps that might show different zoning areas in the county or uses of land in different ways that staff would help prepare. There's goals that are set. The citizens, the public, hopefully is coming together and having at least a somewhat common vision of what they want Winona County to look like in 10 years. And that results in the comprehensive plan, which is then made reality through zoning ordinances, hopefully. And zoning ordinances, of course, are basically laws that involve land use. So they define uses in zoning districts, so those are defined in maps. Natural resources are addressed, just protecting public resources, but trying to balance that against allowing people to use their land in a reasonable way. And then other plans come into that. There's other departments, other things that have plans that might influence how the county's going to look in 10 years. There might be housing studies, small area plans, watershed plans, park plans. Some of that is stuff that needs to be considered, and some of it isn't when you make a decision. But all that then feeds into going up to the county board and the budget. And so the county sets the budget, taking into consideration, trying to balance the needs and priorities. And to a great degree, the budget is going to determine I shouldn't say it that way. If the resources are allocated to do what the goals have, that will help move it forward. And state agencies provide some support when you're implementing new programs, but not much, and it usually ends very quickly. So when you take on a new project, a new type of regulation, or a new zoning, there's going to be added costs that then need to be absorbed by the community, and hopefully that those decisions have been made balancing those competing interests. Okay, so I wanted to go into the details of each of the sort of entities that work together on this. And the first is the Planning and Environmental Services Department, just introduced themselves. And that basically the director of Planning and Environmental Services, and there's planners that are the ones analyzing land. There's zoning as well, that Eric falls into his realm. And then there's administrative support, which is everything from processing applications to putting your packets together for your meetings. And that's all. Every one of those is very important. So I've listed here, I won't go through them all for you, you can see them yourself, but there's a lot of stuff on the plate of planning and environmental services. They touch a lot of areas, and they're responsible for redrafting ordinances. They're responsible for some inspections and enforcement. There's an economic development aspect, water, land. There's just a lot of areas that they touch. And it's just something to keep in mind in terms of like the resources in the county to be able to manage things. And they're basically the planning department is trying to make sure that everything is done rationally and everything is planned so that it all makes sense. So taking, maybe a non-planner's view of what the community should be like, and then putting that into an actionable things that could be carried out. And they're responsible for the comprehensive plan and keeping the zoning ordinances up to date. Certificates of compliance and inspections and building permits. And they do a lot of the materials that you will see in your meetings, the conditional use permits, rezoning petitions, variance petitions, ordinance amendments. And I wanted to invite Olivia, if you would, to just briefly talk about what planners do. So so just to know what goes into when you get that, that report that's recommending or telling you about an issue, what goes into that?
Hi. So we prepare the staff report every month that goes along with your petitions when you have variances or conditional interim use permits. So that process starts anytime a property owner or contractor comes in or calls us in our department, basically inquiring about the project and what it would take. We then work with them to explain the process and what would need to happen in order for them to apply. Once they actually make application, we go out and do a site visit with them, typically on site. And then we do a desk review, which includes a lot of the layers that you see in Beacon, which is our online GIS mapping platform, if you're familiar with it. But it takes into consideration things like soils, prime soils, wetlands, setbacks, feedlots, really a lot of different factors that could influence the project depending on what they're proposing. We also look at things like road classifications, what the township had said at the township meeting that they attended. We take into consideration any neighbor comments when the mailing goes out. Then we look at the criteria and the responses that they've provided. So we kind of try to package all of that up into a staff report that you can then use to inform the decisions that you're making. And if at any time there's things that you feel aren't being provided or addressed that you would want us to cover or highlight, please feel free to let us know, because we're trying to give you an overall picture to use in the meeting time, but oftentimes some of these can be pretty complex and have a lot of moving parts. So definitely trying to just provide you with the most information that we can.
So basically, the information you need to make your decisions is often technical in nature and not something that, you know, I or you have been trained to really be able to look at and identify. And that's where the reports and the counsel provided by the Planning and Environmental Services Department hopefully gives you a technical understanding of how these the conditions of the property, the changes being proposed, and how that would impact your findings of fact and your decisions on your findings of fact. That's a big part, I think, of serving on a board or commission is you get a lot of information. And you get a lot of information, and public has an opinion on a lot of things, but the public is trusting you to a certain degree to really know that information and help represent good decisions based on the additional knowledge that you have that someone from the public may not take the time to go through and understand before deciding how they feel about an issue. And sometimes that's a good thing. Sometimes it's not a great thing, because sometimes the public doesn't understand why an issue went a certain way or made sense. But that happens to every commission, board, school board out there. Okay, the Board of Adjustment. So every county with the zoning ordinance zoning ordinances is required to have a board and adjustment, and it's an interesting board because it's not allowed to have county commissioners on it, and it's not allowed to have county employees on it, and it's not allowed to have elected county officers on it. So basically, it's 5 members that represent a viewpoint that is outside the sort of the institutional framework of the county. And that's very intentional. It's required by statute. And in our ordinances, we require that at least 4 members reside outside a municipality, basically in a township or a town, and not be, I guess, not be dominated by a urban view, and try and balance that. The 2025 Board of Adjustment members are listed there. And basically, the main issue that the Board of Adjustment sees before is variances. There's some other things that that could come before them if someone appeals. If Doug makes a decision they don't like and they want to appeal it, they could bring that before the Board of Adjustment. But by and large, you're looking at people asking to use their property or change it in a way that's not currently allowed under the ordinance. Yes.
Can you elaborate a little bit on what outside of variances, what is adjustment will be responsible for?
Sure. So I've outlined it out there, which basically is if ever any decision made by the planning department or any land use decision made by anyone in the county, if someone disagrees with it, even if it's not something that ordinarily goes through the Board of Adjustment or the Planning Commission, they're allowed to submit an appeal, and that would be heard by the Board of Adjustment. After our ordinance requires that first the county administrator has to review it before it goes to the Board of Adjustment. I would assume that's to try and see if it can be resolved or whatever without needing to be appealed. But that's basically for the Board of Adjustment. That's probably the two things that could happen.
Would that be like if someone was denied a CUP or something?
Well, it could be.
Be more of an administrative, action, like a development certificate that would be issued.
Right. It can come from just about any avenue. Could be one of us wrote a letter to a property owner that says you have a junkyard. We're out there, we counted 6 cars. They're inoperable. You have to remove them. Property owner would just says for discussion purposes, disagrees that they're all operable, that they're salvage, and I don't have a junkyard, and they want to hear an opportunity to be heard on that. It could be a determination that we looked at a proposal and said, nope, this is not a permitted use in that zoning district. They could appeal for various reasons to say, yes, it is, and try to find segments in the ordinance or the comprehensive plan that supports their position. So we have to take things at face value and apply the ordinance, setbacks, performance standards, and it could be off track for any number of reasons. You know, we've gotten some of those. In some cases, it's been fines. I think I don't know if that's the appropriate channel, but there could have been some after the fact or some fees that were applied to a situation. And, you know, they want a relief valve to consider that. But that's more of an administrative one. I don't know that there's some gray area there too with that. But you're also, the Board of Adjustment would be a weed board. If we wrote a noxious weed letter that said you have to destroy something, you have those abilities to look at the facts and see if our order or a letter was appropriate for the case on that, so.
But I didn't hear the answer. If somebody wants to appeal a decision on a conditional use permit, do they go to the?
No, they do not. That's through district court. If the planning commission and county board has made a decision, that mechanism would be through district court.
And we talk about local control, that's what zoning's all about. So why would things first go to?
Because the due process says that according to an ordinance that the process for that is through your planning commission and through the county board. You can't circumvent that by having another board undo what official boards have already decided.
Could we change our own rules to allow that?
Yeah, that would take.
Somebody to be able to appeal a county board decision to the Board of Adjustment.
Right, I like to avoid court, that's a waste of time, energy, and effort, both from the staffing, county staffing, and the citizen. So I thought the Board of Adjustment was going to have more power and control over those things first. And then if you didn't like their decision, then you would go to the court.
Yeah, the statute is very expansive in terms of I think the Board of Adjustment sort of meant to be a due process safety net. If somebody doesn't like a decision and it doesn't really fit into the process, they could bring that to the Board of Adjustment and be heard. The board or the county commissioners can give the Board of Adjustment additional duties. And then the scope of what those could be, we'd have to look at that language of the statute and some of the legal background.
So if somebody has a request for a conditional use permit, it comes through the planning commission first, correct?
Right.
And the planning commission says, no, we do not approve it. They can take it to the Board of Adjustments. And the Board of Adjustments can override the planning.
Well, the planning commission actually makes a recommendation to the county board, and then the county board votes on it. So in terms of conditional use permits, those don't go through the Board of Adjustment.
The Board of Adjustment only hears variances in administrative appeals, so appeals to administrative decisions. The planning commission, that's not an administrative decision, that's I think that's a public decision that the county board ultimately makes. So the planning commission is only making a recommendation. Their recommendation isn't binding. The county board decision is the official.
With that said, is a county board decision an administrative decision? It's not.
It's done by an elected body, public decision. What administrative decisions are what you vested power in your staff to do without that public process. And that's why the appeal process is there to, because those administrative decisions are being made on a daily basis without any further public review or decision making. So the county board, planning commission, Board of Adjustment, nobody's involved with the majority of the decisions that we make every day. It's that's all done when you're adopting ordinances. So you adopt ordinances, you vest your staff with a certain amount of administrative power to make decisions or issue permits for things that are permitted within the zoning ordinance, but then certain things within the zoning ordinance are rise to public review. And those are your conditional uses, and you'll see that list in the ordinance of all the different conditional uses required to go through public review. So that's no longer administrative. That's public review. Ultimately, the county board. Your elected-
Public review would have to go to the courts or something.
And then, yep, since the elected body is making those decisions, once the elected body, the highest elected body of the county is the county board. They make that decision. The only place that you can appeal that decision then is to district.
It's in the BOA, Board of Adjustment.
Right.
When he, rule, he reads his little shtick afterwards and it says that.
So I'm still not real clear about how conditional uses get to the Board of Adjustments. You have,
We don't.
They don't.
Just one committee.
Only so variances, the Board of Adjustment is for variances. The planning commission and county board are for conditional use permits.
okay,
And conditional use comes to the county board, and the county board approves them or denies.
yeah, now, and I thought in the case of Raymond Yoder, and this, stop me if I'm going off the rails here, but there was a request for a conditional use permit for his property that went through the board.
That was a variance. Because he was proposing to do something that wasn't allowed by the ordinance.
So that was a variance, not a conditional use. Okay.
Sometimes it can get a little confusing because somebody might be proposing a new dwelling, for example. And that new dwelling might require a conditional use permit. You're on less than 40 acres or something like that. So the trigger for the conditional use permit, so that's going through, it's making its way through the planning commission and county board. And at the same time, what we see it a lot is that, that maybe they don't meet a setback or they're on prime soils. And so at the same time, that is also going through the Board of Adjustment to be heard for that prime soil standing. So, but each of them have their own lane and they're reviewing a certain aspect of that development process.
That's why we have Jordan on that straddles both of the committees, so there's
Yes.
Yeah, I have a question. So, the fourth adjustment has to, squeeze in that powers and duties window. They have to take consideration of the township's recommendation. Does the planning commission?
The planning commission, I do not think that is in their, among their requirements.
However, we do get the report.
We- Yeah, and it doesn't, and again, it doesn't mean they have to follow the township, but they do have to consider it. And
And I guess like, what is that consideration? Just says we read it out loud and don't agree with it, or what's consideration?
well, from what I've seen at the meetings, they will get a form back from the township that says we agree or disagree, or here's why. And there's usually not too much of it, too much discussion of it, probably unless there's, the township is elaborating a little bit on how it impacts them. But, you know, my perception is that it does carry weight among the different bodies.
If somebody comes in for a, is it both a variance and a conditional use permit? They have to go to the township first? Okay, so they have to go, that citizen has to go to their township, and there is that form that says if you agree, disagree, or no comment.
Support or does
Yeah.
not support or does not have.
So that's the first step in their process of applying.
And we do that because we want them to be aware of what's going on and for them to have an opportunity.
But unfortunately, it doesn't always happen.
It's got better.
Let's,
Timing,
Yeah.
timing is critical.
So I guess like, the recommendation, say we're evenly split and a township's recommendation, part of that consideration can say, well, it's in favor or opposed, or evenly split. I believe the consideration would be to go in whatever the township.
Or would it be evenly split? It's nowhere, so not even number.
Well, not, I guess, 4-6, correct?
If somebody.
the pros and cons are,
Right,
Rather
let's say
than a vote.
we have a voting body that's somehow even.
Somebody doesn't show up. Yeah.
But I guess that's like that's the only way I can determine that consideration is there. Otherwise, again, if I don't agree with them on principle, or again, I'm just representing my community's opinion vastly.
I would look at it like any other public comments. So you're not making decisions based on the public comment. You're taking that in and hoping to learn something more about the proposal that's maybe we don't know about already.
Sure.
And so that information that you're getting from the public comments can be used then to make your findings and connect to those criteria. So any decision has to be made on those criteria, not on, it's not popularity contests.
Right.
You know, a public comment is just a public comment. It doesn't matter if you've heard it 100 times or one time. Really what you're looking for in those public comments is a piece of information that can be linked to your criteria in your decision-making process. And it's really a way just for due process for people to be heard, you know. You have to provide that for people to say what they think about it. But you can't make a decision based solely on public comment. Wouldn't hold it before.
and
Just a reminder on time.
okay, how we doing?
You've got 35 minutes.
35 minutes, okay. Real quick on appeals, two things to keep in mind. The zoning, the county gets the authority to zone from state statutes, said earlier. And so if there's a state statute that says the county has to do something or can't do something, that's like a hard stop. A lot of times the county has some leeway. On the flip side, in most areas of law, if you don't like a decision of a government entity, you need to exhaust all your appeals within the administration before you could go to court. So within that context of what you're allowed to do, you could consider or looked into adding steps to additional appeals to the process that they would have to follow before they went to court. All things being equal, I say that generally I would have to research the specifics of what was being proposed. So. And we did touch on the planning commission. So again, this is a mix of municipal and rural members, liaison to the Board of Adjustment, and a county commissioner on this. So hopefully that planning commission is getting a lot of viewpoints and has an idea of what each body is doing in regards to issues they're addressing. Planning commission also holds public hearings, which are an important due process element. And we'll talk about that a little later, about how those should go. And there's the county attorney's office. Basically, the county attorney prosecutes crimes, serious crimes, and then lesser serious crimes. Some crimes are prosecuted by the city of Winona if it's a misdemeanor that occurs in their jurisdiction. But the county attorney also does juvenile delinquency and adjudication and truancy and child protection and another entity that has a lot on its plate. And then there's the other side with the civil council and representation of the county. So the county attorney is basically the legal advisor to the county board and to the other entities within the county and departments within the county. Basically a resource to tell you what you can do, what you can't do, what's possible, what's not possible, but also providing counsel, because a lot of times there isn't a straight answer that you know what the outcome will be based on your decision, whether it would hold up in court or whether someone would sue or not. And at least in my practicing law, I often view it as helping the entity manage risk. I can't tell you what's going to happen, but I could try and help you understand what risks you're taking by taking one course versus another course. So if you were going to make a decision without adopting findings of facts, I'd probably tell you probably shouldn't do that, and here's why. But you're the decision makers, and you don't. The county attorney, the planning department, we don't make the decisions. You and the board do. And then the county attorney, there's one county attorney, and then there's 8 assistant county attorneys and administrative support. And all the assistant county attorneys basically take on the work that is assigned to the county attorney under the statutes. And so most of the assistant county attorneys are working on criminal matters, because that's public safety is a big part of what the office does, child protection as well. Okay, and this part of it you probably know. The meetings, all meetings are open to the public. They need to be advanced. They're third Thursday of every month. There's the address in case you don't remember how you got here today. And typically meetings have public participation in terms of giving people an opportunity to speak. But along with that, you also, it's good practice not to get into a conversation with the public during a meeting. So the public could say their comment, but and the board or commission could consider it and take it in and follow up. But often if an entity gets into a back and forth with at a public meeting like that, it quickly you lose control of the situation. So that's a generic agenda. Usually you just have the formalities of approving the meeting agenda, Pledge of Allegiance, approving the minutes from the last meeting, correcting any errors in that, and then hearing updates from the other boards and commission and county board, and then hearing new petitions or applications. And you'll almost always be making a decision at the meeting on applications or petitions that you're considering for the first time, though sometimes if more information is needed, applicant, the petitioner could be asked to gather more information, rather, so that the Board of Commission can make an informed decision. And, usually they would want that rather than just denying it because you don't have the information you need. There is a 60-day rule that we have 60 days to make a decision from when their application or petition was complete. So the clock is running, and sometimes though, when there is more information to collect and it's going to go beyond that 60 days, can mutually agree with the landowner or petitioner to extend that, or the county does have the unilateral right to extend that. And that just needs to be done by a letter that explains why. And that the statute authorizing that is one of the rare things where you don't need findings or anything like that. It could be, the statute doesn't require any reason at all, any particular reason or standard for extending it. You just have to tell them you're doing it and why you're extending it. And they can't really say, no, that's not a good reason. So the board meetings basically use a basic framework of Robert's Rules of Order to sort of keep things on track. Robert's Rules of Order, if you're doing all of it, it could be very complicated, but you only need to do a very little small part of it to keep the meeting on track. And really that's introducing a topic, someone makes a motion, someone seconds the motion, you have discussion on the motion, someone calls the question, then you vote on it. And, from a technical standpoint of Robert's Rules of Order, and you might have seen this like in Congress, members are supposed to address the chair back and forth and not really address each other. But in our situations, that's probably a little too formal, and it's often more constructive to have a little bit more back and forth. But the chair sort of is responsible for following the rules that keep the meeting on track. The board and commission adopt your own rules of how to conduct your meetings at the beginning of each year, and you guys could amend those at any time. It just takes a majority of the vote to change something in that procedure. And what I would say about that, those are designed basically to hopefully let things run smoothly. Robert's Rules of Order is kind of like, the person who's the loudest and the most intense shouldn't get to talk all the time. Everybody should have a fair opportunity to talk. So you really don't need to get into the micro details, which you could if you like that kind of thing of Robert's Rules of Orders. But it's mostly just common sense, a few things, just keeping the meeting on track and making things don't spiral in a direction where people aren't getting their due process in the discussion. We talked about these other things, I think, already. The role of staff in the presentation, discussion, creating a record, and findings. So just real quickly to where we've come here. So we start with comprehensive plan, leads to zoning ordinances. We apply legal standards and case law when we need to. You guys come up with a legally defensible basis for your decision, and you put that into findings of fact. And that's basically what goes into the decision making. So each part of those everyone has a little piece of, and hopefully informs your decision when you're applying that all to consider the findings of facts and the standards that apply to it. And at the meetings, of course, the planning department is here, I'm there, and any legal questions or planning questions could be addressed by staff if you have them.
So in changing upcoming next meeting and trying to change, using the comp plan as a basis when it's trying to change a zoning ordinance, do you have to have findings of fact to justify changing a zoning ordinance? Or is it a popular public opinion?
Well, it can't just be popular public opinion. There has to be a rational basis related to the power and authority of the county, which sort of usually falls into the broad, protect the general public safety, welfare. And you don't need formal findings of facts for everything the board does, but everything should have a rational reason for that support the decision. And hopefully that comes from something in the comprehensive plan that is a goal that is trying to be, put in, made into.
That, ordinances need to be changed depending on popular demand.
I don't think it says that in the comprehensive plan. No. And that's, and again, that's exactly what I said. Any decision should have a rational basis. It might be a popular decision. It might have be a popular decision. And what the public thinks is important. But again, when it comes down to making the decision, it has to be legally defensible and has to fit within the authority of the entity to do it. Yes.
Done board of adjustments.
Yeah. Oh, with the public? Mhm. Right.
Online before you're asking questions, you can answer us and actually have a conversation.
Yeah, so, and again, this is where it's a little less formal. So typically what ideally would happen is that the public would make their whatever they want to say, or the petitioner would say what they want to say. If the board had questions, they could address and answer those questions. And if the public wanted input, they would do the same thing in terms of just saying what they think. And if the board had questions, they could ask questions. But the thing I think you want to avoid is like getting into an argument with the petitioner, over an issue. And it doesn't usually happen. I don't think I've ever seen it happen, but it is fine for the board or commission to, if they have questions that will help inform their decision-making, to ask the petitioner.
And you can always ask public questions, but it has to be a very pointed question.
Yeah. Yes.
Is there a statute of limitations for things that people bring up claiming happened?
Well, there for a lot of things there is it, and I have a book that lists all the statute of limitations, and it's about this thick in Minnesota. So the statute of limitations are different in every situation, depending on what laws are being applied. It's sometimes that's, it's unfortunate, but sometimes a legal analysis has to be done to figure out what the statute of limitations is and argue about it, because it's not all clear. We have the 60-day rule that requires us to act. I think the board has a rule about not addressing an issue that they've voted down for a certain amount of period of time. And that's in their rules of procedure, like I described, that you would have, that you could change whenever you want. So the commission and the boards and the county board are free to put those types of things into their rules if you guys think it's necessary and useful.
Gene, were you wondering though, like, is there a time space, like a limitation of how far back you can go before you consider a comment that somebody's making? Right. Like, so if somebody's making a public comment and it's like from 10 years ago, 12 years ago, can you discard that because of the time frame?
Yeah.
There's really no statute of limitations there. It's really your own personal judgment if you think it's still valid. It's like any public comment, like you don't have to take. Your job during the public hearing is to listen, take in the comments, and then close the public hearing. and then discuss the merits of the case, and that might include a discussion of some of the comments. But it doesn't necessarily need to. You need to be focusing on those criteria and coming to a decision. Does that
Well,
make
you make
sense?
it sound a lot simpler. Yeah.
Well, isn't it though?
Yeah, yeah, and you know, the discussion may be about whether the comment is still relevant after 12 years, and members might have a different viewpoint on whether it is or isn't. In some cases, it might be obvious, in some cases, it might not, depending on what it was. But you all have the discretion to decide when you vote, how to use that information when you vote.
Is it appropriate in a public hearing? You know, we get a lot of people come and address all these boards. We always ask them their name, their address. Is it appropriate to ask them if they have any professional degree, licensure, or anything to give their comment credibility, or is it just personal feeling? Are we supposed to make that distinction, or can we probe a little bit and ask them?
Well, that's a tough question, actually. It's a fine line. I think it is fair to if somebody is stating something as fact, as to making an effort to verify whether it's factual or not. I don't think, you know, boards want to be interrogating members of the public when they come up, you know, to speak. So, you know,
Well, a lot of them will say if they represent an organization, or if they're a doctor, or.
yeah. Okay, conflicts of interest. We'll go through these real quickly. So under the statutes, if you are discharging your official duties and would be required to take an action or make a decision that would affect your financial interests or those of an associated business, you need to recuse yourself. And the interesting thing about that, there's no bright line rule as to what that is. So, you know, if I own, you know, 100 shares of McDonald's and McDonald's comes up, you know, that's probably not going to influence my decision. But if I own the building that's McDonald's wants to buy, then that would influence my decision. So you really need to use your judgment on that. And there's, you know, a lot of faith placed on you to make those determinations and identify them when they happen. And I'll say that it's always better to be more conservative than less conservative in terms of deciding whether it's a conflict or not. Just kind of take the ethically safer course because what we all do is public, and it's best to be open about those things, and sometimes those conflicts tend to come out too if the community knows about them. So bias and prejudgment, this sort of goes along the lines of treating everybody equally. And again, it's a common sense sort of principle. In a criminal case, you have a burden of proof, and in the decisions you're making, you have the findings and the standards that you're looking at. And if you have some judgment or bias that would cause you not to pay attention to that standard. So in other words, it would, instead of thinking about how does this impact that stream, you're thinking about, oh, that person got in a car accident with me and I'm mad at them. I don't want them to do this. And so those are the kinds of things that would be bias or prejudgment. You should basically, you know, be open to whatever might be the best decision. Open meeting law is very important. So basically, purpose, no secret meetings, ensure the public's right to be informed, allow members of the public to be present at meetings. What exactly is a meeting is not defined, but generally, if there's a quorum, a majority of members together, and you're talking about business that has to do with things that are before you, that's going to be considered a public meeting. There's also serial meetings that could happen, particularly in email communication. And this is, it's easy for this to happen and you need to be careful of it, is passing information serially about something that's coming before you among board members. You know, an email stating your opinion to somebody and then somebody states their opinion to somebody else, that is generally considered a violation of the open meeting law. So, and basically it's because all your deliberations should be public. So, you know, you reviewing your agenda packet, you're taking your knowledge of the community, you're, you know, collecting whatever information you need to support your opinion. And then you get to the meeting, the public gets to hear how you get to that decision.
But Steve, if this happens often, you receive some information or find an article or something that's relevant.
Right.
You, as a member, can send it to staff and then staff can send it out to the whole membership.
Right. And that's exactly right. The safest way to do it is if you have information you want to share or request is to send it to staff, and then staff send it out to everybody or put it on the agenda or something like that.
That way it gets something in the-
Yeah.
And going on field trips too. If people want to go visit a site, it just can't be a quorum. Two people could go and visit a site, but for
Yeah.
best use of people's time and everything, but not for board of adjustment.
Yeah.
Planning, it would be, what, 3,
So there's 9 members.
5 altogether could possible. Avoid it if all possible.
Yeah.
Yeah. Or
Yeah. And
don't discuss what's going on.
Yeah.
What's your questions?
That goes to that prejudgment piece too. If you're having conversations with other people in the public, and they're wanting to talk about specific issues, you wanna be listening, you can have those discussions, but be careful that you're not kind of showing your cards too obviously ahead of time. If you have a opinion about the petitions before it comes before you. You are quasi judicial, so you don't want to be always telling people that you have, this is how you're gonna vote essentially. Before you receive the packet, before you hear public comments, and everything else that goes into the record. Because that can be, like, again, evidence of prejudgment, and can get you in trouble with the decision.
And that'd be the same if you're on site, you wanted to see one of the, look at their kitchen and giving them.
And likewise, if there's information that you're getting out of the field or from other people and that's influencing your decision, you need to make sure that that gets to staff so we can share it and make it part of the record. But also during discussion, you need to let people know that, hey, this is a piece of information that I saw that's influencing my decision, so that everybody has that same piece of information.
Kind of gets to the meetings, so it's really important for the chair to recognize and elicit, conversation from all the members, because all the members who may have information that's, important for everybody to hear.
Is there a requirement to recuse? Like, if I'm not so distantly related to something coming before us, obviously there's an ethical concern there. But is there consequence if I don't?
If there's any question, I guess seek out the county attorney.
Yeah.
Any doubt.
Yeah. So because there's no bright line rule, what I would do if that came up is ask you what the situation is, and then I'd go research a bunch of cases to find similar situations and how courts have decided them to try and make a judgment call, or balance the risk of how big a problem it is or isn't.
The other way I look at that, again, like he would be more conservative on that. And if there's even a perception of a conflict, then, that might be enough.
What is it, the statute says the appearance of conflict is in.
Yeah. I don't think I had.
maybe to this person, or, you know, this.
Something like a neighbor comes up.
Right.
Oh, I don't want.
Yeah.
I'm in a pinch point. I don't want to be here. Do I just say, I'm not going to be here this week because, right? Do I need to be here this week because?
Yeah, no, you could just recuse yourself from the vote or just say you're not going to vote because, you know,
Yeah, you're welcome to.
You'll still be in trouble with your neighbor because.
Yeah, that's a good. That's
Yeah.
again,
yeah. And,
We could talk through that with you if that ever comes up.
Yeah.
Yeah, I didn't think you just don't. Just you still be there. So.
right, yeah.
One thing I just want to touch on, because it's come up the last month, we encourage you to look at sites. Staff tries to put a pretty good background, familiarity of a site that's in question, but nothing sometimes replaces visiting a site to see it firsthand. There's a whole nother set of protocol when you're approaching a private property, and in any case, we encourage you to work with your staff, make an arrangement with the property owner, because when people are kind of freewheeling into a property, that there's a whole nother set of dynamics that you have to be kind of aware of and cognizant to. So
One thing if you're staying like on public property, public right away, but if you're going onto the property, you're approaching the property like that.
Mhm. Yeah, and you know, and the reason it isn't a bright line rule is, you know, you all live here, you know people, you that's why you're serving on the commissions and boards that you do. So it's you'll know something about just about everything probably that comes before you, but you just want to avoid those ones that would make you bias or prejudge. And particularly in controversial issues, the appearance of bias, as Doug mentioned, or appearance of a conflict is every bit as damaging as a real conflict. Years ago, I was on the school board for Winona, and I used to say, the truth isn't what happens at the meetings. The truth is what is printed in the paper the next day, and it can never be changed. But it's kind of that. If there's an appearance and that's what people perceive, it's very difficult to have them trust your decision. I think we are just about done. Just wanted to point out resources if you have questions or you know, want to develop more expertise around these things. You know, planning and environmental services, of course, has the land use expertise and process requirements. You know, our office could provide the legal advice or point you to statutes, regulations, ordinances, and explain them to you if they're unclear. And then there are training and other resources. I don't know what all is available, but there's a lot of associations that have trainings that deal with land use issues.
We're getting close to the end, and so this was just day one of this. If you guys felt like you needed more and need more on a particular topic or something like that, you know, feel free to let us know. You can put that in something. Then
the one screen that Steve had up about the different programs, we could create an hour or 2 hour presentation on each of the 35 topics.
I don't want to take your job.
Yeah, and the last PowerPoint that was presented for training that I looked at when I did this was 125 slides. So I cut it down to 25. Yeah, that was yours, yeah.
People need to, but if you're Googling, make sure you're following Minnesota
Yeah.
laws. And through our Minnesota Counties Intergovernmental Trust, MCIT, they have a few different publications. They have some videos on it. And then there is a very detailed training that's coming up in August that people really want, but that's unfortunately it's in St. Cloud area.
Yeah.
It's not, but you can go to their website. They have a few different resources there include MCIT.
Yeah, and that's a good point about Googling. There's a lot of things that go into whether what you're reading is relevant and or true. And it's even more complicated now because now Google is putting AI results at the top or explanations, and AI is simply just flat out wrong. And so,
Cities and counties.
Right, cities, yeah, and different, and counties in different states are different than counties here. And in some cases, you can analogize, and in some cases, you can't. So, any other questions? Yes.
I'd just like you to talk a little bit more about, something I see come up a lot is when someone wants to change the findings of fact or, differ from what the staff recommendation is.
Mhm.
I'll often hear, members of our boards just say, well, change it so it says it does. And I know you can gather a certain amount of information from our discussion,
Mhm.
but I'm assuming what you would like is for us to also give you, lay out our reasons for changing that finding.
Right, right. So, yeah, so the preferred way to do that would again to be to slow down, look at what the standard is and talk about what it is about that standard you disagree with or feel should be changed. And, you know, we're more than happy to make those changes, however the board or commission decides. But if it all happens really quickly without a lot of detail, it could be hard to go back later and sort out exactly what that language should be.
But you have an opportunity to stop staff question
Yeah.
as standard question.
It's really doing a disservice to the judgment you're trying to make by not defending it as you're making.
Mhm. Yeah, yeah. And using the right standards, you know, to base that on.
Like, at that point in the conversation, you want to be looking again at those individual criteria. You can go through each one, or you can pick out specific ones. I mean, you could just say, I have a problem with number 3. Can we look at that one closer, read it out? You know, attempt to provide reasons why you're coming to a different conclusion.
Mhm. Yeah, and the same is true if you don't understand, you know, why it's written a certain way or what exactly it's saying is the case. We could certainly, you know, go through that. Not always legal language isn't always the clearest language.
And of course, you also have to have support from your other commissioners to
Right.
pass the.
Yes.
How many findings of fact are you supposed to have positive to approve?
You know,
You don't have to have all of them. do you?
there's a dispute about that actually I've just started researching. It's my understanding that you don't have to have all of them. You just have to consider all of them. But not everyone agrees with that viewpoint. And I want to find the legal basis for, it's not obvious from the statute which way it goes. And I want to get that sorted out.
I think our
Financial.
Hmm.
Seeing password sometimes is a consideration.
Well, how about,
You have to consider.
is there, are all findings of fact considered equal in each petition or are some of them more important than others?
I think that's a judgment that the board or commission can make. There are things that have to be considered or should be considered in the decision making.
I think, you have a better.
The one thing I just wanted to point out is that, you know, that pertains to planning commission. If you're at the board of adjustment, that's very cut and dry. It's like you have to meet each of those criteria in order to be granted. If there's one that is not met, then it needs to be denied. But if you are the planning commission, that's where it's a little bit, I think, commission is more germane.
Well, that's where I'm at.
The one that comes up, and I know I think somebody, Board of Adjustment, you do a lot with, the little lots down along the river that need septic
Yeah.
systems. And most of them have been approved, but you know, you can, you know, they don't all need to have a drain field. There are septic systems that don't require a drain field. So again, there's somewhat of a jump and they're usually very expensive and it's kind of a judgment, but it seems like those are kind of, and again, my interpretation is staff almost always, I don't look at them in every case, but almost always saying to leaning towards approving, but on very small postage size lots.
keep in mind with the variances and the Board of Adjustment, staff spends an exorbitant amount of time getting to basically rethink it, minimize, downsize, retrofit. I mean, we try to sort out the ones that are probably not too palatable for an approval and tell them as much. And so we try to get the ones that are probably for that property owner, the best case scenario moving forward for consideration. So that's behind the scenes.
Yeah, I mean, there's been times where somebody's come in to us and asked us for this, that, and the other thing, and we just tell them straight up, no. You know, it's just a no.
There's a lot of, there's a lot of requests that come through that never make it to any kind of permit being, applied for. Because you provide the information, they, and they realize that their property just isn't, it just doesn't work for what they're trying to do.
And there-
Those are the administrative things that.
Exactly.
Exactly.
But you know what? You never hear of them because most of the time it's kind of clear. No.
I mean, if they're, that's the thing is with those types of conversations though, if they push it. We can say like, hey, we don't think this is a good, a good request. But usually that's couched with, you always have the ability to make a application to the board. Planning commission.
Yeah.
A lot, we will tell them straight up that I don't know that staff can support this proposal. And that's maybe why you don't see quite as many that come through without our support. But we do give them those options and we provide all the information that for them on the front end.